So Sarah, let's say it was a mixture of both.
A mixture of both.
How would the practitioner be expected to bill that client? How would the bill read?
So I would have expected to see a lump sum bill on file with, doesn't have to be particularly lengthy, but a description as to the work that was being billed for. So work to date with a summary of what's happened, whether there's been expert reports obtained, whether instructions have been taken, whether conferences have happened, whatever it might be. Some sort of fairly generic description, which I see on a lot of lump sum bills. And with the usual rights on the bottom of the bill in relation to all of the things that the Act sets out about the type of rights you have to explain to the client that they have in relation to a lump sum bill.
And would that bill also include a reference to a further amount for funds to be placed into trust for future bills or out-of-pocket expenses?
Yeah, so it would need to set out the work in arrears and the work in advance.
Yeah. Yep. And I know it sounds simple in retrospect, but I've been in this situation where you're very good at litigating or whatever your various specialties are. You're not brilliant at costs in a firm like this. I hope I'm not insulting anyone, because other experts are doing it for you. That's what happened to me at Holding Redlich. I had a costs clerk, I had a CEO of the firm, I had a whole administration that dealt with costs. I relied on cost consultants to do my costs disputes. And much of that I left to others. It was therefore very easy to make some dumb decisions about your ethical obligations, your communication obligations and your billing obligations to a client.
Does anybody have anything they want to add to that or comment about that sort of scenario? Does it seem strange to you? Yes, everyone's nodding. Yes.
All right, why don't we go on to case number 4. Who's going to talk about that? Is that yours, Sarah?
So again, this is another matter which is coming close to being finalised now, but I thought it might be of interest to you. In this case, the solicitor was appearing for his client in the Magistrates Court in relation to a matter where the client was being sued by his former solicitors for some outstanding costs. And the client had a lot of views about the various reasons he had as to why he shouldn't pay a proportion of the costs that he'd been billed. So the new solicitor was appearing in that Magistrates Court hearing, and in preparation for that hearing, the client was the type of client that would make a lot of contact, so be emailing a lot, calling a lot, with very helpful suggestions about how he thought the case should run and what submissions should be made and what the arguments should be. And even to the extent that he prepared what he considered to be an extremely helpful spreadsheet, which was colour-coded and it had certain columns relating to certain items on the bills, and he wanted it presented to the magistrate and he wanted it submitted in various ways, how explained to the magistrate how it clearly set out why he shouldn't have to pay these bills.
Now, if I could just interrupt, quite a few of you are grinning, and I'm sure that you've actually had clients like this before, whether you're in a CLC or whether you're in a firm or in a sole practice. And we even have complainants like this who are very interested in how their complaint is going to be dealt with, and they're so interested they do a lot of research and they tell us exactly which cases we should be relying on and what their view is about other matters. So it's not uncommon. I'm sure we've all experienced that.
And looking at the matter, I took the view, I went and inspected the practitioner's file, and I think he had done a good job in sort of dampening down the client excuse me, along the way, but perhaps didn't do a lot of explanation maybe on the day of court to explain, now we're going to wait and see how things go, and we're going to wait and see what indications I get from the magistrate. And I don't know if I'm going to use the spreadsheet. He didn't really have that sort of discussion. Anyway, the matter ran for 2 days, and the solicitor, his version of events is that he felt it was his professional job. He'd been instructed to appear at the hearing. He would use his own judgment to run the matter the way he saw fit and make the arguments that he thought were going to be the most helpful to his client. And he didn't put the spreadsheet to the magistrate, and he didn't put some of the arguments that the client was wanting him to put, and he was certainly getting the nod from the magistrate a number of times about how it was going and how it wasn't going. And in his view, he felt he used his professional judgment in that respect. Now, the client then, doesn't really matter what the result was. He didn't have a good result, but even if the result had been good, I don't think he would have been impressed that his material was not used. And that's the main substance of his complaint to us, that his lawyer did not follow his instructions in that regard. He probably would have been happy with
You
it.
may not have been, but they often don't, do they, Marcus?
So that's, I guess, the scenario. And I wondered, before I go on to say what's going to happen, but I mean, are you all nodding? Do you understand that situation where you have clients that have got particular views as to how they want things done? Yes, I'm presuming so. So the matter's going to be dismissed. It's in the process of being dismissed. That's if Michael approves that decision, but that's what I expect will happen. And we'll be relying on the case of Giannarelli and Ray, which is the High Court case, which I'm sure you're all very familiar with, where we'll be explaining to the client, to the complainant, that a solicitor and barrister must use their own professional judgment and their discretion to use as to how they should best advocate the case. And that they have an ethical obligation not to raise spurious arguments or waste the court's time in relation to arguments that they don't think are going to be successful or going to add value. And I guess, although this will be a good outcome for the practitioner in that he won't have a finding against him, he has had to spend time with me going through the process. He's had to make his file available. He's had to provide written explanations to the complaint. And perhaps the lesson for him, I guess, is that if he could have done a better job at managing the client's expectations along the way, then it may have avoided the complaint being made. Don't know, with that type of client, sometimes you can't avoid it, but I think he did probably a halfway good job in relation to that, and probably could have.
There's another lesson in that, Michael, which is be very careful of clients who are already in dispute with their former solicitor.
Yes.
The comment was, be careful of clients who are already in dispute with their former solicitors. Well, it does, yeah, it does, and you people who are experienced in medical negligence understand both the value and the impediment created by defensive medicine. But the reality is, as David has said, it's very easy to fall out of love with a client as it is falling in love. And that real estate agent practitioner fell into the trap of believing that because everything was ticking along nicely and there were sweet arrangements and everyone was in the joke, so to speak, that nothing could go wrong. And as we all know, we've seen in life, so many relationships break down, professional relationships break down for the most unexpected and unusual reason. And as practitioners, you all know, which is why people need lawyers to anticipate that things can go right.
Those sort of clients have to be managed very carefully because, I've had instances where I've said, well, I think the advice that you're getting is very good and I can't recommend that you change ship because it will cost you for me to get up to speed and read your enormous file or whatever. There are other instances, indeed I've got a person at the moment I'm acting for where I thought the advice that the client had been given was not the appropriate advice given the client's overall objectives. It was sound advice within a certain narrow context, but looking at where the client wanted to ultimately end up, it was not the best advice. It was about spending money on an interlocutory stoush where we were better off basically saying, yes, we'll consent to that and we'll save our money for the bigger battle. So, and then you get, but it's really where, you know, that forum shopping is perfectly acceptable and it's something that we're all used to. It's where they're in dispute with their solicitors about fees. And I think it's glaringly obvious where somebody has been grossly overcharged, but there are probably a majority of costs dispute cases where it's arguable that the costs are reasonable and you need to be very wary and not immediately accept what the client says, because of course there are two sides to every story.
That is true, and I understand your earlier point where the client is in dispute with their solicitors, but I think for those of you who are here from the community legal centres, you would hear a lot of these stories, because I know in my experience, you know, going throughout regional Victoria and speaking to community legal centres and Victoria legal aid officers, a lot of that gets aired out in the centres, and because they need a second opinion. They want to go and have their concerns validated, and they don't want to pay again for that. So the community legal centres are very valuable there. And although most of those matters do relate to cost disputes that may not amount to anything or may not be gross overcharging, a lot of these complainants do have meritorious complaints, and sometimes it's unfortunate that complainants, persistent complainants in our case, are often tarred with a brush of that isn't really warranted. So sometimes those matters need to be looked at closely to see.
Well, I'm not saying they shouldn't be looked at closely. I'm just saying as a practitioner, you immediately need to turn on the alarm bell and just be cautious.
Yeah, and as you said, you can't take everything that the client says at face value. It's the same with the practitioner. But if I can just mention something, or comment on one of your other comments, you were saying, giving a second opinion and often having to have to say whether advice that they've received is good or bad. Barristers often find themselves in that situation as well, particularly where they're briefed very late at night and they're expected to appear the following morning, and they're up, until the middle of the night researching and preparing. And I spoke to a barrister recently who had concerns about a particular practitioner, and it was a criminal matter. It involved a minor. The minor was in custody, should not have been there. Proper steps weren't taken to get this minor out on bail. And on the morning of the hearing, the barrister turned up. The solicitor didn't, and the barrister got a serve from the magistrate, and eventually just had to say to the client or to the minor and the minor's mother, you need to go somewhere else. You need to get proper advice here. Here's a solicitor that I know who happened to be a solicitor who lived in his same apartment building, and in that situation, the minor and the mother got good advice. Out on bail, the matter was dealt with much more efficiently than what it had been dealt with initially. So it's something that is dealt with on a regular basis by barristers, by yourselves, by lots of